I would like to present the panel of the speakers. So first of all, I would like to present George Apostolou. George is a partner in Cyprus office at Harneys, where he specializes in the areas of financial services and regulatory law, corporate and commercial laws, banking and finance, private equity and trust, as well as the project and asset finance transactions and security structures. And also, hi George. Yeah, and also we have
hi Max.
We have Kerry Graziola, director at Harneys BVI. Kerry specializes in voluntary liquidations, directorship of BVI companies, and client accounting, with a more recent focus on hedge funds and investment management.
Thanks, Max.
Hi, Kerry. And we have also Taras Lytovchenko as a counsel at GOLAW, and he specializes in the field of corporate and commercial law. And Taras regularly advises clients on market entry and liquidations of businesses in Ukraine and outside, restructurings and corporate reorganizations and corporate governance.
Hi, Max. Thank you.
Hi. So I will not take any minutes from our speakers to present their quite interesting questions. I will just say that we will have at first Taras, who will say why you need to consider the liquidation of your foreign company now. And then we will have George and Kerry, who will present the modes of winding up, common pitfalls, and even quite practical questions about the costs of liquidation in Cyprus and BVI. Also, we will ask all your questions, so please leave them below, but we will try to do that after the presentations of our speakers. Thank you, and I now pass the microphone to Taras. Please, Taras, yeah, go ahead.
Max, thank you again. Hello, everybody. So probably most of the participants have already heard about the latest significant changes in Ukrainian tax legislation, which took place in 2020 and which introduced new rules for cooperation and interaction between Ukrainian residents and the foreign companies. One of such most important changes was the introduction in Ukraine of the rules for reporting and taxation of foreign companies, or so-called controlled foreign corporations, or CFC rules. Let me just remind you that in a very simplified form, the CFC rules mean that owners of foreign companies will be obliged to report annually to Ukrainian tax authorities on their foreign companies, and as well as to pay like income tax in Ukraine for such companies, of course, subject to some certain exemptions. The first reporting period for CFC rules will be 2022, and the first report may be submitted together with the annual declaration for 2023. That means that the declaration for the first two reporting periods may be filed in 2024. Thus, as of now, the owners have actually less than 1 year left to prepare themselves for the CFC rules upcoming. It is pretty obvious that most owners of foreign companies are not very happy with the new strict obligations for various reasons. I'm now even not talking about paying taxes for the foreign company, but in certain cases, disclosures are also not very desirable. While in many other cases, preparing a report and calculating the taxable income will definitely require involvement of both local lawyers and foreign legal advisors, as well as auditors from both sides. Of course, it will usually require additional annual costs and for quite large amounts. We're now seeing that it is quite a standard case that in many complex multi-jurisdictional corporate structures, which were built like 10 or even 15 years ago, certain foreign companies have ceased to perform their functions and to have any economic interest for the owner already for like several years now. In this connection, of course, we see that some owners want just to step aside and to forget about unnecessary foreign companies. Unfortunately, doing nothing and just forgetting about your foreign company is obviously a wrong decision, which at the same time may, of course, bring some very expensive costs afterwards. Why? Because it is likely that the CFC rules will work together with the automatic exchange of financial information according to the Common Reporting Standard. If this mechanism will work, CFC owners will not be able to hide their foreign companies from Ukrainian tax authorities. Ownership of such CFCs will be disclosed in any case. So when the tax office will find out about such foreign company about which the owner has not reported or has not paid due taxes, the fines will be very serious. In particular, for various types of violations, such as, for example, failure to submit or late submission of a report or failure to disclose information about existing CFC, the law provides for fines in quite substantial amounts. For example, they vary approximately from 100,000 hryvnias to about 2 million hryvnias for each violation. So you can see that it's pretty substantial. For those business owners who are now wondering how to proceed further and whether it is worth keeping an already unnecessary foreign company, especially if it has ceased to perform its essential function in the business, the legislator has established quite an interesting rule, which is called tax-free liquidation. Basically, to put it simply, the law stipulates that in 2020 and 2021, the income received by owners of foreign legal entities or similar establishments like partnerships or trusts from the liquidation of such company will not be included in taxable income for the purposes of personal income tax of the company owner. I just need to note that the so-called tax-free liquidation indeed is not absolutely tax-free, because it provides for exemption only from the personal income tax, while the military duty of 1.5% will still have to be paid by the owners. Also, there are several conditions under which the owner can apply the tax-free liquidation. And first of all, tax-free liquidation will apply only to foreign companies that were created or registered no later than May 23rd, 2020. Secondly, liquidation must begin not earlier than January 1st, 2020. And must be completed by December 31st, 2021. This is very important. Finally, in order to be eligible for this, the owner must submit to the tax office, together with his annual tax return for the relevant reporting year, an application for exemption of such income from taxation. The owner has also to attach to it a description of the liquidated company, a description of assets, as well as their value, the assets which were received as a result of liquidation. Also, financial statements of the company shall be attached there too as well. But in any case, there are no strict prescribed documents by the law which would be required to file. In any case, although it is not directly prescribed, we would recommend to collect and keep all documents issued in the course of liquidation. For example, just a shareholder's decision on liquidation may be required to confirm the starting point of the liquidation. One more important thing to note is that the tax-free liquidation will apply to cases when the income from the liquidation of the foreign company is transferred from the nominee shareholder to the favor of the ultimate beneficial owner. That is, if a resident of Ukraine owned a foreign company through a nominee owner, the income from such liquidation can still be exempt from taxation in Ukraine. And furthermore, this does not require the initial transfer of corporate rights from the nominee to the real owner. In this regard, using this option of liquidation of an unnecessary foreign company, it is possible to achieve a positive result in at least two directions. First of all, if there is no CFC, there is no obligation to pay taxes for such CFC in Ukraine, nor to submit reports and notifications on such CFC. Secondly, the law now allows to, almost without a tax burden, to receive assets earned by the CFC personally to your name. And such funds do not have to be returned to Ukraine or converted into hryvnia. So at first glance, it may seem that the procedure is pretty straightforward, but in fact, these matters are really complex and have many pitfalls, both in Ukraine and in foreign jurisdictions. For example, almost in every case, it will be necessary to carry out a certain kind of pre-liquidation measures, without which the procedure is almost impossible. For example, to restore the original accounting documents if they were not maintained like in many offshore jurisdictions. Also, it is very important for you to understand that in order to apply the tax-free liquidation, the liquidation of a foreign company must be carried out in a general liquidation procedure, while in most cases, the results of the strike-off procedure will not be eligible. At the same time, the strike-off procedure can be used to terminate a foreign company that has no liabilities, no assets, and no distribution has to be done. So now, having a general understanding of why to liquidate a foreign company, George and Kerry will tell in details about the options for winding up foreign companies in Cyprus and in the British Virgin Islands. Colleagues, please.
Yep. Thanks, Taras. Before we will, I will pass the microphone to George. I need just to mention that all the presentations in Ukrainian and in English will be distributed on your emails to all registered participants. So, I mean, you will not need to make notes or something like that. Now we can proceed with Cyprus and BVI perspective of the question. And now I will pass the microphone to George.
Thank you, Max. Thank you, Taras. It's very nice to be participating in this very interesting webinar. As Max has mentioned at the beginning, Harneys is an international law firm. We have our headquarters in the British Virgin Islands, where Kerry is sitting right now. And we also have two offices in Cyprus, where I am sitting now. We will give you a brief overview of what liquidation or winding up is about in these two common law jurisdictions, which are quite different from the Ukrainian legal system. And I will begin with Cyprus. We will cover each slide together with Kerry so that we cover each slide's points which are similar for both jurisdictions simultaneously, and then move on to the next slide. So beginning with Cyprus, we have to say there are three main modes or types of winding up or liquidation. There's something called the voluntary winding up, which has two sub branches, an insolvent and a solvent voluntary winding up. The difference is that in a solvent winding up, the company is able to pay its debts as they come up in the next 12 months, and therefore the directors are able to swear an affidavit in court called the Declaration of Solvency, which has a statement of assets and liabilities attached to it. And then a liquidator is appointed upon the commencement of liquidation resolution and liquidates and proceeds with the winding up and liquidating of the company. The second branch of a voluntary winding up is called a creditor's voluntary winding up, or an insolvent liquidation. And in that case, the company is not solvent. It is not able to pay off its debts, and the members and the creditors have a separate meeting, either on the same day or a day apart, and they appoint a liquidator. The creditors choice of liquidator, if the choices are different, prevails in that case, and it is the creditors who have the upper hand in leading the liquidator through the liquidation. Although the liquidator has duties of his own and powers of his own, and is acting independently of anyone, unless he has been appointed by court, in which case he's an officer of the court. Now, that's the first type of liquidation, the voluntary liquidation. As we said, there's an insolvent and a solvent sub-branch of voluntary liquidation, which is the easiest. Usually what we see in Cyprus is a member's voluntary liquidation with the company being solvent. There are another two types which are more rare. We have a winding up by the court, which is instigated by a special resolution of the company sometimes, or a creditor taking the company to court, asking for it to be wound up in case there's a debt exceeding 5,000 euros and it has been due for over 3 weeks. It's what is called usually, and you must have heard it under English law as well, the just and equitable grounds winding up by court. And the third and last mode of winding up in Cyprus is called the winding up under the supervision of the court. This is basically the same as a voluntary liquidation, but at some stage, either the liquidator or an interested party, such as a member, the directors, or a creditor, applies to court to supervise the whole process. And this is usually done because it has certain advantages. You can, through that process, appoint an additional liquidator to co-sign anything that the original liquidator signs, and therefore keep an eye on him, basically. It automatically operates to stay any litigation against the company, which might serve the liquidator from a strategic point of view in where he or she is with the liquidation. It also allows for the creditors or the members to keep the liquidators escalating fees by having some supervision by the registrar of companies or the court, depending on what the court will decide, because it usually demands of the liquidator to file quarterly reports with the registrar of companies. So in summary, before Kerry steps in and gives you the BVI winding up types or modes, there are 3 main types of liquidation in Cyprus: the voluntary winding up, the winding up through the supervision of court, and the winding up by the court. Kerry?
Thanks very much, George. Max, Taras, thank you very much for having me. I am honored to be speaking with these gentlemen today. I will give you the options under the BVI legislation for liquidations. There are 2 basic regimes in the BVI, and both legislated by different pieces of legislation when it comes to liquidations of BVI companies. The first is voluntary solvent liquidations, which are legislated by the BVI Business Companies Act, and by far the most common type of liquidations in the BVI. And then the next 2 points are insolvent liquidations, which are legislated by the Insolvency Act in the BVI. The distinction here is solvency, and as George mentioned, the definition of that is the assets. If a company is solvent, the assets will equal or be more than the liabilities, and the company will be able to pay its debts as they fall due. With an insolvent company, the opposite is true. There are 2 types of insolvent liquidations. There's a member's appointment, which is out of court. In this instance, the 75% or more of the members need to pass what is called a qualifying resolution to place the BVI company into insolvent liquidation. And then there are the 3 appointments by the BVI court. By far the most common grounds by which a liquidator can be appointed by the court to an insolvent BVI company is insolvency of the company. So the company is unable to pay its debts and is balance sheet insolvent. The 2 second appointments by court are more rare. The just and equitable grounds, examples of these are whereby there's a fundamental failure of the company to meet its objectives. There has been fraud in the company. There is a deadlock in the management of the company, etc. There's also the public interest application route. Under this route, only the Attorney General or the regulator, the BVI Financial Services Commission, can make an application under the public interest grounds. In this case, there must be proven to be prejudice to the integrity or reputation of the British Virgin Islands, which is why the applicants can only be the Attorney General or the Commission, the Financial Services Commission. In general, an application to the court can be made by the company itself. It can be made by a creditor, a member, the supervisor of a creditor's voluntary arrangement, the commission, the Financial Services Commission, as mentioned, the Attorney General, or the administrator of a BVI company. The key differentiation to note here is the liquidator. So under the voluntary solvent liquidation, it is less regulated who the liquidator can be, and we will talk about that in later slides. For an insolvent liquidation, the liquidator can only be a BVI licensed insolvency practitioner. There are approximately 30 such individuals licensed and regulated in the BVI by the Financial Services Commission. So that is one of the criteria for the appointment of a liquidator. At Harneys, we only perform voluntary solvent liquidations for conflict reasons. We do not have a practitioner that holds an insolvency license, but we do know all of the insolvency practitioners in the BVI, and we have very good working relationships with the insolvency practitioners in the BVI. For the purposes of this discussion, I will be concentrating on the voluntary solvent liquidations because that is what is most relevant in light of the recent changes in the Ukrainian tax law.
Thank you, Kerry. Moving on, as Kerry mentioned, the most common type of liquidation is the members' voluntary liquidation. At the Cyprus office, similarly with the BVI office, we concentrate usually on solvent liquidations, although we handle insolvent liquidations with the assistance of a co-liquidator, an external insolvency practitioner, and thus in the BVI, so does in Cyprus, a liquidator needs to be a registered, a licensed insolvency practitioner. Now, what is the basic process or steps to take when you are starting off with a voluntary liquidation? And let's start with the members' voluntary liquidation, which, as we mentioned, is the most common type. Given especially the very tight time frame that Ukrainian law provides for the tax-free liquidation, as Taras just pointed out, which is the end of 2021, someone who has a company in Cyprus or a special purpose vehicle which they do not need anymore, or which they wish to liquidate to take advantage of the CFC rules amnesty provisions, they have to be ready with prepared audited financial statements when they come to the liquidator. Otherwise, time will be lost. And obviously this is, as Taras mentioned, important time preparing all those audited financial statements in order for the liquidator to accept appointment. once the financial statements are audited and prepared and hopefully also submitted with the registrar of companies, then one can proceed and prepare the declaration of solvency, which we talked about just in the previous slide. And the board of directors, or the majority at least of the board of directors, prepares this. It is an affidavit which is sworn before the court registrar in Cyprus. It does what it says on the tin. It declares the solvency of the company, that the company can pay its debts as they come up in the next 12 months. And it provides a statement of the assets and liabilities of the company, which supports that declaration of solvency. Then the next step is to pass a special resolution at the EGM, at the extraordinary general meeting, and this means that the shareholders have to sign a resolution called a special resolution, which requires a 75% majority of the shares held by those shareholders in order to commence the liquidation. It is from this moment that officially liquidation in the form of voluntary winding up is deemed to commence under the operation pursuant to the law. And this is again important, as Taras mentioned. This is probably the document that you will need to present to the tax authorities in the Ukraine to show that your liquidation has been instigated within the required time frame, and that it has been commenced validly. The challenge from a Cypriot law perspective is to complete liquidation by the end of the year, so as to meet the provisions of the Ukrainian law, and that will be challenging, especially if the books or the audited financial statements or the tax release certificates of the Cyprus company are not already at hand or in order. So you should bear in mind that 11 months remaining until that deadline that Taras talked about is quite a tight deadline. Usually a voluntary winding up takes about between 6 to 12 months. If anything goes out of the ordinary, those 12 months might be exceeded. So it is wise to commence your liquidation of your Cypriot companies as soon as possible, in case you need to put everything in order to meet that deadline for the completion of the liquidation by the end of 2021. Now, there are statutory advertisement provisions in Cypriot law, so that special resolution and the declaration of solvency will be sent to the registrar of companies, who will in turn publish them in the official gazette of the Republic of Cyprus. And the idea, of course, is to inform the world at large that this company, which you may have dealings with or may have had dealings with, and which you may be a creditor of, is going into liquidation. There are some forms that help you communicate this to the Register of Companies, which must be filled in by your administrative service providers or the liquidator at some point onwards. In that same special resolution, usually beyond the commencement of liquidation, a liquidator is also appointed. They have to be a natural person. They cannot be a company. They cannot be a legal person, and they have to be a licensed insolvency practitioner. Again, the appointment of the liquidator is communicated to the registrar of companies and is published in the official gazette. From that point onwards, the liquidator proceeds with certain duties and powers, and their job is to liquidate the assets of the company. First of all, discover what assets there are, and then liquidate them and distribute those assets down the line to all the parties which have a rightful claim. And we will talk about who those are in the subsequent slides. Once all of that is done, the liquidator convenes a final general meeting and presents the final accounts of the company to the members, who approve, hopefully, that statement, those accounts, and then registers the resolution of that final meeting with the registrar of companies, and within 3 months from the publication of those accounts in the official gazette, the company is formally deemed to be to have been wound up and liquidated properly. Now, I have to mention something important. As of the commencement of the liquidation, which is the special resolution passing by the general meeting that we talked about a bit a while ago, the company should cease any business unless it is business which is important or beneficial for the winding up of the company to be completed, and also something very important is to note that as of the appointment of the liquidator, which comes usually but not necessarily in that same special resolution, the board of directors of the Cypriot company ceases to have any powers unless that special resolution expressly allows them to have some residual powers for specific purposes. So in a gist, that is what is a member's voluntary winding up, which is the most common type of liquidation in Cyprus. And with no further ado, I will invite Kerry to also tell you what is going on with the BVI.
Thank you, George. Sorry, Kerry. Before Kerry will proceed with BVI aspects, can you say from a practical point of view about the distribution from the liquidator? Do you think that the liquidator will be able to transfer the assets to the ultimate beneficial owner, who is not the registered shareholder? Being in mind that the real shareholder or registered shareholder, nominee shareholder, will also somehow approve this transaction.
Yeah, that's a very good point, because it relates to what Taras again was talking about just before. Provided that there are no creditors, or the creditors have been paid off by the company before the enters liquidation, or by the liquidator, the remaining assets will need to be distributed to the registered shareholder. Now, that's the liquidator's duty. The liquidator cannot pay or distribute those assets to any other party unless, of course, they are expressly consented to do that, or permitted to do that by the registered shareholder and, of course, the UBO. In those cases, it would be possible to, for the liquidator, provided they feel comfortable doing it, to pay directly to the UBO the assets. The concern that the liquidator will have would be that the registered shareholder may have a claim. So if they receive an express consent or a consent in writing to pay the UBO instead, then the liquidator should probably feel comfortable to do that to save time. Another way to bypass the problem of having a registered shareholder is to, before instigating, or just before instigating liquidation, to have the UBO registered as the shareholder of the company, so that you, as liquidator, pass on and distribute all the assets directly to them. If that is something that would not interfere with any Ukrainian legislation, that would also be a potential way forward. So you have the nominee shareholder transfer the shares to the UBO just before you enter liquidation, and you then have the liquidator distribute all the assets to the UBO, who is also by that time the registered shareholder.
Good, good. Thanks. Kerry, please.
Thank you, Max. So in the BVI, the process is similar to Cyprus, but there are a number of important differences in the BVI. First of all, I'll start off with the timeline. So it's not on the slide, but in general, voluntary solvent liquidations in the BVI can happen quite quickly, between 4 to 8 weeks, depending if there are assets to be distributed. If they are not, it's on the lesser end of that timeline. But in general, within 2 to 3 months, the company can be completely liquidated and removed from the register of companies, which is quite quick. Given the timing, there is a little bit of time to liquidate your BVI companies, but as George mentioned, we would encourage you to initiate the process sooner rather than later, so that you're well within the deadlines given by the Ukrainian tax authorities. So in the BVI, a company needs to be in good standing before it can be voluntarily liquidated. What does that mean? That means that it is up to date with its annual government license fees. Those will be paid to the government via the company's registered agent. The directors need to declare solvency of the company and as well as draw up a liquidation plan. The liquidation plan has general information about the liquidation, such as the duration, why the company's been liquidated, the liquidator to be appointed, the remuneration of the liquidator, and whether the liquidator will be required to send the members a copy of the liquidation account. These two documents, the Solvency Declaration and the Liquidation Plan, as well as the notice to the general public of the liquidator's appointment, are the three documents that are required to be filed with the BVI company registry. Along with the Solvency Declaration, the directors need to draw up a statement of assets and liabilities of the company at the latest practicable date. A key difference between the BVI and Cyprus is that a BVI company is not required to file or produce audited financial statements. So this will not be a requirement. Most liquidators do ask the company to produce a set of financial statements for their own risk assessment and solvency considerations, but it is not a strict, explicit legal requirement for a company to produce financial statements, whether or not they are audited. The only requirement on a company is that it is able to, with reasonable certainty, determine the financial position of the company at any given time. So we do find in quite a number of instances, there are no formal financial statements for a BVI company. There are often management accounts or internal accounts, which are very helpful for the liquidator to assess the solvency of the company. The directors and the members need to resolve to appoint the liquidator and place the company into liquidation. There's no requirement for these meetings to take place via a meeting, a formal meeting. They can be via unanimous written resolutions. According to the legislation, and depending on what the company's memorandum and articles of association require, normally a 50% member vote is required to appoint the liquidator by written resolution. So 50% or more. If the company is regulated in the BVI, i.e. it holds a regulatory license, such as a fund, approved manager, etc., the regulator, the BVI Financial Services Commission, needs to give its approval for the company to enter into liquidation, as well as the approval of the name of the liquidator. Once that is all done, the three documents that I mentioned, the Solvency Declaration, Liquidation Plan, and Notice of the Liquidator's Appointment, are filed with the BVI Companies Registry. The filing can take place by the company's registered agent. It can take place via a law firm, or it can take place via a BVI insolvency practitioner firm. Normally, within a day or two, the registry comes back with its approval or disapproval of the filing. In most instances, unless there is something obviously wrong with the documents, the registry will approve the filing, and that is the point at which the liquidation commences. It's quite key to note that the liquidation does not commence on the date that the resolutions are passed, but rather when the registry approves the filing. And one key thing to note is that the documents need to be filed within 14 days of dating, or else they become stale dated and the registry will not approve the filing. Similar to Cyprus, there are statutory advertising requirements. The responsibility of these is on the liquidator. The liquidator needs to cause to be advertised his or her appointment in the BVI as a first port of call, and then also in the company's primary place of business, principal place of business. If that jurisdiction is outside the BVI, then the liquidator needs to arrange for the advertising of his or her appointment in that jurisdiction. Subject to any creditor payments, the surplus assets are then distributed to the registered shareholders. So very similar to Cyprus, the distributions normally take place to the registered shareholder unless there is explicit written instructions to the liquidator in which the registered shareholder wishes to pass the assets directly to the UBO, which is possible. Once the company no longer has any assets and liabilities and the liquidator is satisfied that they have performed their duties, the liquidator needs to file with the company's registry notice of the completion of the liquidation. Once that is approved by the company's registry, the company is deemed to be dissolved and a certificate of dissolution is issued by the company's registry. So that is the point at which the liquidation has been completed and the company's name has been removed from the register of companies.
Kerry, thank you for that. And I have another question from our participants. We actually have some unverified information that the liquidators on BVI are not happy to take and to liquidate the companies with assets and then to transfer the assets to the shareholders or to the beneficial owners. Can you confirm that?
I can confirm that is not the case, Max. There are various because the liquidator role is not regulated in the BVI for voluntary solvent liquidations. Really, anybody that meets the criteria can be appointed. So a lot of people who tend not to have a lot of experience with liquidations tend to shy away from liquidations where they are distributions. Obviously, it's up to the liquidator to determine whether they are comfortable in that situation with the solvency of the company and with the declarations that the directors are making. But it is very common for the liquidator to make distributions from a BVI company.
Great, thank you.
Thank you, Kerry. I should point out that in Cyprus, the liquidators have no problem whatsoever as well to distribute assets in a voluntary members winding up. Usually what will make the difference with for the liquidator feeling comfortable to proceed with distribution of assets is having all tax clearance certificates that all taxes have been paid, and to be able to have a good overview of the creditors and any contingent liabilities. Provided the liquidator has those and understands exactly what has and what is going on in the company, they will proceed with the distribution of the assets. Before we go into the next slide and discuss a little bit what the duties of a liquidator in this kind of liquidation are, I should also mention that as in the BVI, and as Kerry mentioned, there are statutory timeframes for submitting the documents, and beyond those they become stale in some occasions, like the special resolution commencing the liquidation if it is enacted or passed beyond 5 weeks after the declaration of solvency is dated, then the liquidation will not be deemed to be a solvent liquidation. It will be deemed to be an insolvent liquidation. So care must be given to those timeframes, and because they're statutory, and the repercussions of missing them or not meeting them will be important. Now, moving on to the duties of a liquidator, what is the job of a liquidator in a voluntary liquidation? It's basically to take possession and protect the assets. They will take the books of the company in their possession and all the documents. The liquidator will have to look into the affairs of the company and make sure that there has been no wrongdoing by the directors, the last directors or the previous directors of the company, and that no assets of the company have been transferred over the last 6 to 12 months to any one creditor in fraudulent preference to other creditors. Of course, in a solvent liquidation, that will rarely be an issue, because it means that the company has the assets to cover all of its liabilities. So basically, the liquidator, as an independent officer, will need to take a look at which stage the company is in from a financial and legal perspective, protect the assets, take them under his wing, and then begin identifying who the contributor is and the creditors of the company are. When we're talking about contributors, we basically mean who are those shareholders who have not paid up the entire amount or nominal value of the shares that they hold. Under Cypriot law, a shareholder can be the owner of shares and may owe the value of those shares still to the company. If that is the case, then the liquidator can go after those shareholders and request and demand that they pay that amount to the company. And of course, very importantly, the liquidator has to identify who the creditors of the company are, so that they proceed and pay those creditors off before they wind the company up. Otherwise, the creditor will have a claim against the company and probably against the liquidator themselves. If there are any disputes, ongoing disputes, it is the liquidator's job, since the board of directors has and their powers have largely fall by the side as of the appointment of the liquidator, and the liquidator's job is to adjudicate those disputes, take them to the end with the goal of completing the liquidation as beneficially and in the best interests of the company as possible, and of course the creditors and the shareholders. And then once the liquidator has identified and took possession of all the assets that belong to the company, and what they need to do is they need to realize the assets and apply the proceeds to pay and all the debts and the liabilities that are out there, including, very importantly, any taxes or social security contributions owed in case the company had employees in Cyprus or elsewhere. And after paying those claims or liabilities or debts, then the surplus of the assets will be distributed to the shareholders. As we mentioned, the liquidator needs to be an individual. They have to be a natural person. They cannot be a company. And obviously, the reason for that is that at any point, someone may go and find the liquidator and have a claim against them, whereas a company could have been liquidated itself and vanished in thin air. So it is there for accountability reasons mainly. As we mentioned before, the liquidator must be independent of the company. He's depending on what kind of liquidation is being instigated. He's either an agent of the company, a trustee of all the creditors and the contributors, owning certain duties towards them under the law. But in the case of a winding up by court or under this provision of the court, he will be deemed an officer of the court first and foremost, and has to report to the court about what it is that the liquidator is doing during the liquidation. And depending on what the court instructs, the liquidator will need to give interim reports of where the liquidation is at, in case that is winding up by the court. In a voluntary liquidation, obviously you don't have that restriction, and the liquidator is deemed to be an agent of the company, as we mentioned, and has to act for the benefit of all the creditors as a whole, and the contributor is the shareholders as well. Kerry?
Great, thanks, George. I'll just deal with Olga's question because it relates to the previous slide. So Olga has asked, can BVI documents be submitted online? Yes, they can. As I mentioned, the documents that are required to be filed with the registry can only be filed physically from the BVI. So there is no access to the portal, to the registry portal outside of the BVI. And these documents need to be submitted in soft copy PDF format to the registry by the registered agent, the insolvency practitioner, or a law firm. In most instances, documents are electronic. Sometimes the liquidator will ask to see the original of the documents that are required, but in most cases, electronic scanned copies via email will suffice for these purposes. Great, so the duties of the voluntary liquidator are very similar in the BVI as in Cyprus. I'll start with who can act as liquidator. We've already touched on this. The liquidator needs to be an individual. It cannot be a corporate or legal person. The person needs to be obviously not a minor, so over 18 years, and not an undisqualified bankrupt. The liquidator needs to be independent of the company, meaning that the person cannot have been a director or officer or be involved in the management of the company for the past 2 years, as defined by the legislation. The liquidator, the primary duty is to take possession of, protect and realize the assets, identify the creditors or claims against the company, pay those debts and claims in order of ranking. If there's security against certain assets, those would also be taken into account in the process of distribution of the assets. If there are any surplus assets, those will be distributed to the registered shareholders or the ultimate beneficial owner, as we have previously discussed. As a practical point on the distribution, so in the BVI, when a liquidator is appointed, the directors remain in office, but they no longer have any power. So similar to what George mentioned in Cyprus, unless they are given specific instruction or power to do specific tasks by the liquidator in writing. So we find as a practical solution to distributing assets and to save on administrative burdens and time, especially where the asset is a liquid asset such as cash or an investment portfolio with a bank or a broker. As a practical solution, the liquidator would normally instruct the directors to make the distribution to the registered shareholder or the ultimate beneficial owner. This way, it saves on the time to get the liquidator as sole signatory on these accounts, which we know practically can take a number of weeks, if not months, to satisfy the bank's KYC requirements. And in order for the bank to act on the instruction of the liquidator, there are numerous documents that these banks or institutions might want to see. So as a practical consideration here, the liquidator would normally in writing enable the direct or empower the directors to make the distribution directly, because in most instances, the directors are already signatories on these accounts, and therefore administratively, it is much easier and can be done on a more timely basis. The liquidator's appointment is in the public domain, so similar to Cyprus, the statutory advertising of the liquidator's appointment is published in newspapers widely in circulation in the BVI and in the company's principal place of business. So it's not a role to be taken lightly. There are duties imposed by the law on the liquidator, and it is something that is in the public domain. So we often advise individuals who are wishing to act as liquidator, that they should consider it very carefully, and they should be aware of the powers and duties which are placed upon them by the legislation.
Thanks, Kerry. Just to add, first of all, I need to say that all the questions related to the tax-free liquidation in Ukraine, we will answer them after the presentation, not to interrupt our speakers. But we have another question to Kerry. Are you allowed to start the liquidation with the share capital of the company which is not paid?
That's a very good question, and oftentimes we do see instances where the shareholders have not paid up the capital. It depends on the memorandum and articles. If it is possible to have 0 par value shares, in which case there is no contribution which is required, and in most instances, if there are no other assets of the company, or if it is a single shareholder who has not paid up the share capital, there is no requirement for that to be done. So in most cases, we would ask for documentation relating to the write-off of that balance before the liquidation can commence.
Thanks.
Thank you, Max. Thank you, Kerry. I realize that we're running a little bit late, so I will go through the common pitfalls slide a little bit faster. What we usually see going wrong in Cyprus, the client comes and wants to begin a solvent liquidation, and then we suddenly discover, once we get management accounts, that their company is in fact insolvent, either because it was always insolvent and they didn't tell us, or they didn't realize, or because they moved the assets and transferred them and distributed them to the shareholder or the UBO just before the liquidation, forgetting to allow for the payments of auditors or the liquidator after the commencement of liquidation. So that's an important distinction to make. What status, financial status my company is before commencing liquidation, and what do I have to leave into the account if I'm transferring the assets of a solvent company before the commencement of liquidation, so that I do not render the insolvent liquidation impossible for the liquidator. Another common problem that we see is that the declaration of solvency that is sworn by the directors becomes stale because the special resolution is not passed within the 5 weeks, and in that case again you end up with what is an insolvent liquidation procedure, even though the company is solvent, and you need to involve the creditors if there are any. Otherwise you would have to go and cancel the liquidation, losing valuable time, which is in this case of the essence. Some board of directors either forget or omit to give out proper or any notices for the resolutions, both the general meeting resolution or the board of directors resolution, rendering the decisions to commence liquidation and to appoint the liquidator either invalid or at the very least open to challenge by any future interested party. They transfer, as I mentioned, the assets to either the UBO or the shareholder or another single creditor, depriving other creditors of any recourse to those assets. In that case, that is quite serious. And of course, if it's a solvent company, that can be dealt with. If it is an insolvent company, that is also a criminal offense, and the statute, Cypriot law, allows the liquidator to go and have recourse to that creditor and take the property back in his care and his possession. We mentioned the rendering the company insolvent just before liquidation. The liquidator sometimes is not independent. Again, this is an important point to take into account. The liquidator promises things that they cannot deliver, or promises timeframes that they cannot deliver, or they have no control over, like completing for example, the liquidation within a specific time frame, and then discovering that the tax authorities will not issue a tax clearance certificate before that time frame lapses, and thereby having to go back and explain to the UBO that the liquidation cannot be completed on time. So realistic timelines should be always communicated to the client. And finally, something that we already mentioned, the tax liabilities that arise must be dealt with. You do not want the tax authorities to be your creditor and chase you and revive the company once you have liquidated it.
Good. Maybe one question. You mentioned the tax clearance certificate. Is it complicated procedure, and what are the terms of that?
It is not a complicated procedure, but it is a time-consuming procedure. The tax authorities require to see audited financial statements before they issue a tax clearance certificate, which will allow a professional liquidator to proceed with the liquidation. So that's usually where the liquidation takes a bit of time, and that is another important, very important reason why audited financial statements should be ready from the get-go, so that you do not lose any time having to prepare them to get that tax clearance certificate, thereby allowing your liquidator to immediately proceed with the distribution of assets once they have that confirmation that any taxes have been settled, and there is no danger that either the liquidator themselves or the company will be chased after the liquidation is completed and the company revived.
Thanks.
Thanks. I'll just comment on that question from a BVI perspective. So obviously, BVI taxation is not an issue for a BVI company because BVI companies do not pay corporate or income tax. However, it is possible for a BVI company to be tax resident in another jurisdiction. So oftentimes, the liquidator would ask to see the tax clearance in whatever jurisdiction the company is tax resident. If there are tax payments or tax submissions that need to take place during the liquidation, which we often find if there is if the company owns a fixed property in another jurisdiction outside the BVI, we often find that there has to be a tax submission after the property has been transferred to the owner of the company. So in instances like that, the tax clearance would have to be given during the liquidation, and the BVI liquidation cannot be completed until that process has been completed. Common pitfalls, very similar to Cyprus, solvency versus insolvency. They are very distinct legislative considerations as well as liquidator considerations for a solvent versus an insolvent company. So this is the most common pitfall. Similar to what George mentioned, if the company is insolvent and is already in voluntary solvent liquidation, there are obligations on the voluntary liquidator to kick the company into insolvent liquidation, which means the legislation that now applies to the liquidation changes from the BVI Business Companies Act to the Insolvency Act. There's also an obligation on the solvent voluntary liquidator to call a meeting of the creditors within 21 days. And then the official receiver in the BVI or a licensed insolvency practitioner will need to take over the liquidation. So it's very important at the onset to get the solvency aspect correct, because then you know who can act as liquidator and which legislation will legislate the liquidation. With a voluntary solvent liquidation, the documents become stale if they're not filed within 14 days. We mentioned that previously. They will simply need to be redated, or else the registry will not approve the filing. A common pitfall is the liquidator is not independent of the company and therefore is not a valid liquidator, and it can be challenged. Statutory advertising, this may be a common pitfall on the liquidator's part, because they may not know which jurisdiction the company has been trading or operating in, and therefore they may be likely to miss creditors or claims against the company by not advertising the liquidator's appointment in that jurisdiction. Similar to Cyprus, not identifying all of the creditors is a common pitfall, and or making distributions in the event that the creditors have not yet been paid, which is also a common pitfall. It's not as formal as in Cyprus in terms of the actual process in the BVI and the filings. In most cases, by the time the company is ready for a solvent voluntary liquidation, the creditors have been paid off, the liquidator has been paid, any lawyers involved in the liquidation have been paid. So at that point, the company will truly be solvent in that it will have no liabilities. That is the most common state of affairs that we see the companies that come to us for liquidation.
Thanks, Kerry. Moving on, we'll talk a little bit now about the differences between a liquidation and what is called a strike-off of a defunct company from the registry of the Companies House in the case of the BVI or the Registrar of Companies in Cyprus. There are two main types of strike-offs. It is not a formal liquidation. No liquidator is being appointed. Rather, the company, following a specific process or procedure, becomes stricken off the public record. The way this is done is twofold. It can be instigated by the company itself. It involves the company sending a letter to the Registrar of Companies, letting them know that the company has been dormant and it has no operations. The registrar then notes that and sends a letter in a specific time frame, requesting that be confirmed to them. Usually the company does not respond, or responds by confirming that the company is still dormant, and given another statutory time frame, the Registrar of Companies proceeds and strikes off the company. So that's the first type, where the company instigates the strike off. Obviously, it is much more complicated than that, and there are some requirements that need to be fulfilled and criteria before the registrar will proceed with striking off the company, not just the exchange of correspondence between them and the company. And the second method through which strike-off can happen is when the registrar of company discovers that the company has not met some of its statutory duties, especially its reporting duties, including the payment of its annual levy. There's a €350 annual levy that needs to be paid by every company. And if you miss paying that, or you miss filing your annual report, including your audited financial statements, then the Registrar of Companies has the right by law to strike off the company. Again, as now the case is not as it was in the past, that you could utilize those provisions and allow the Registrar of Companies to strike off your company to your advantage. There are specific requirements for the Registrar of Companies to proceed and do that, including the preparation of audited financial statements in case of the first method of strike off. The main differences between a strike-off and liquidation is that the strike-off can be done much more quickly. You don't need to go through the statutory steps that a liquidation has to go through, which are more stringent, more formalistic. It requires no liquidator to be appointment, but there is a very important downside in that, as opposed to liquidation, where the company may be reinstated through the application of any interested party, any contingent creditor, within 2 years of it being formally wound up. In the case of the strike-off, that time frame extends to 20 years. So any interested party, including any director, member, or creditor of the company, may reinstate through an application in court the company within 20 years of it having been struck off. Kerry? Thanks,
George. So in the BVI, it's similar to Cyprus, but the timeframes are quite different. So what is a strike-off? A strike-off is whereby literally there is a strike through the name of the company. It still exists on the register of companies until such time as it is dissolved. Now, the time frame between strike-off to automatic dissolution once it has been struck off is 7 years in the BVI. In general, we don't recommend strike-off. There are significant risks to the directors, in particular to the company, and I will go through those shortly. So there are two main types of strike-off. There is a voluntary strike-off, which is also called a Section 213 filing with the registry. In that case, the company has ceased to perform any business and the requisite filing is made with the registry. It happens immediately and therefore can be done quite quickly. The other one is a strike-off by lapse of payment of government fees, which is by far the most common form of strike-off. So you basically would just stop paying your government fees on the company, and within a certain time frame, the registry would strike the company's name off. The risks on the directors are a company that is struck off cannot commence or defend legal proceedings. The directors' members cannot act in respect of the company, in respect of any transaction or the affairs of the company. A strike-off does not prevent the company from being sued or by creditors lodging a claim against the company, and it does not prevent the company, very importantly, from incurring liabilities, including registry and government license fees. So these accumulate for the period of 7 years, and if any transaction or if the directors suddenly need the company during that period, they will have to reinstate the company by paying all of the government license fees and penalties to restore the company. So it can be very costly as opposed to a liquidation. A liquidation is more costly at the onset and takes a longer time to effect, but the finality of it is more attractive, especially to directors. One big risk, which is quite new in the BVI, is the economic substance regime, which came into effect in January 2019. This places certain obligations on companies to comply and to notify the BVI tax authority as it relates to economic substance. One very important thing to note is that a company which is struck off still has economic substance, compliance and reporting obligations for 7 years. So it's very bizarre because it places a huge risk on the directors and operators of BVI companies because the law renders, by definition, the strike-off renders the company unable to perform any action, and the economic substance legislation places this responsibility on the company for filing and compliance. So it's one of the things where we definitely advise clients to liquidate versus strike-off, especially given the economic substance burden that is on the company for a period of 7 years until it is dissolved.
Thank you, Kerry. I have to say that there are similar risks for the directors in Cyprus with a strike-off, and to add to that, in case there are any assets left in the company after it is struck off, they become bona vacantia, they become property of the state. And if you ever wish to reinstate the company beyond paying the cost that you have already mentioned, you would also need to secure the waiving of the property back to the company's ownership by the Accountant General of the Republic of Cyprus. So it is not recommended in Cyprus either to go down that route. It has a lot of risks, especially for the directors, but also down the line for the UBO and the registered shareholder.
George, sorry
yes,
for interrupting you.
please.
How do you think about skipping several slides, because we
Sure.
want to answer the questions also?
Yes, of course.
And I feel that costs.
I think we have covered the strike-off, so we can move past this slide if. And again, the restoration, I think we have already discussed a little bit about this, both from the BVI and the Cypriot perspective. The costs we can discuss in the questions and answers time. And
it will be good if you can, in general, say several words about the costs. It's pretty much interesting, I think.
Okay. Well, in Cyprus, we usually see liquidations costing between 5,000 to 10,000 euro, depending on the complexity. The factors that can increase the price is if Harneys is not, our Harneys fiduciary branch is not or has not been the company's administrative service provider or registered agent, in which case the company and its dealings are unknown to us, and that usually drives the price upwards. If the liquidator will need to make serious distributions of assets, again, the risks entailed are going to drive the fees upwards, and if there's any need for statutory advertising outside Cyprus, for example, in the Financial Times, if it's a global company, so as to warn global creditors that the company is going into liquidation. It is not a statutory obligation for a liquidator to do that, but usually liquidators prefer to cover themselves by doing so. A strike-off, which, as we said, is not usually recommended unless the company is clearly has clearly been dormant and has no obligations or liabilities, will range in fees for between 3,000 to 5,000 euros. And again, what will usually increase price is if there are any financial statements and audited financial statements to be prepared, and any annual returns to be filed with the Registrar of Companies to bring it up to date. And Kerry, please go through the BVI costs, if you will, so that we can move forward.
Thanks, George. So the BVI is known as a low-cost jurisdiction, and that also applies to liquidations. You can see the cost is quite significantly lower than that in Cyprus. Generally, this obviously differs per liquidator, but in general, a simple liquidation with of a company with no assets, no liabilities ranges from 3,500 to 4,000. If there's any distributions to be made, that will increase the price. If Harneys is not the registered agent in the BVI, that will increase the price. And that simply is because of onboarding or KYC requirements. If there's statutory advertising outside the BVI, which is a statutory obligation on the liquidator in the BVI, that will increase the price. If there's any litigation or any ongoing proceedings in relation to the company that the liquidator needs to invest time on, and obviously hire lawyers, etc., the price will increase. If the time frame of the liquidation generally goes beyond that which is expected due to, for example, illiquid assets or things like that, that may increase the price. For strike-off, the first method, which is by lapse, simply by not paying the fee, there's no cost involved there, but there is a high risk. The voluntary strike-off section 213 filing is a $500 registry fee. And then the registered agent normally asks the company to pay any outstanding registered agent fees in that year.
Am I correct, Kerry, that you're thinking about taking the companies from other registered agents and to provide services on liquidation? I mean, is it possible?
It is possible, yes. So you can, a liquidator can act for a company for which the registered agent is any agent in the BVI. That will differ by liquidator. So at Harneys, we can act as liquidator for any company. So the only factor to take into account is it will take longer for a company where we do not act as the agent because we have to gather all the KYC, etc. So we won't have the history on who the director shareholders UBO is on the company. That's the key differentiation.
George, can you comment that on the Cyprus perspective? What about, can you accept companies from other administrators?
Yes, absolutely, we can. But as Kerry pointed out, it would take more time if you have to go through all the transactions or identify all the creditors and contributors and begin to feel more comfortable with the financial status of the company before you make the distribution. So yes, absolutely, we are appointed most often by UBOs or BONDs, which are not with Harneys as their administrative service providers. So yes, absolutely.
Good. We have another question for Kerry.
Yeah. Sure. Thanks, Olga. That's a good question. So just to clear up, there is no filing fee for economic substance that you pay to the tax authority. And by the way, the declaration is once per annum. So it's an annual declaration. It really differs by agent in the BVI. I can tell you what Harneys Corporate Services charges, and it also depends on whether the company is performing any relevant activities or whether it is submitting a nil return. A nil return is obviously the most easiest form of economic substance declaration. Harneys charges $150 for that per annum. If the company is doing relevant activities, it ranges between $350 to $500 per annum for the declaration.
Good, thank you. And just maybe to mention, George, have you covered the question about special issues in case a Cyprus company is registered as a VAT payer?
No,
I think the issues.
I don't believe we have covered that already. Any special issues in case the Cyprus company is registered as a VAT payer? Absolutely, you need to apply for that tax clearance that we were talking about, and usually, if there were a VAT registered payer, that will take a lot bit more time for the tax commissioner to issue that tax clearance. So it's very important again to have everything prepared and filed as soon as possible so that you get that tax clearance for income tax, VAT, social security contributions as soon as possible. So that would allow your liquidator to proceed with the distributions as fast as they can.
Good, thank you. We have another question from Olga to Taras, probably about the military duty. And Taras, can you answer this question? Do you see it?
Yep, sure, Max, I see it. So the question is whether, in our opinion, the military duty shall be paid for the assets received in 2020 and 2021. Actually, yes, from our perspective of view, the law clearly.
Taras, can you increase the volume, please? Your microphone. We cannot hear you.
Okay, 1 second. Better now?
Yeah, good.
Okay. So I have told that from our perspective of view, the law in this situation clearly states that the assets received in 2020 and in 2021 will be released only from the personal income tax. There is nothing said about the military duty. In this connection, we tend to think that the military duty in 2020 and 2021 shall be paid.
Good. Thank you. And we have another question. What documents you need to submit for the tax-free liquidation in Ukraine in case of the BVI company liquidation? So that was somehow partially covered by Taras in his presentation. Maybe just to confirm that, Taras, can you comment that, and then maybe I can add something?
Yeah, sure.
Yeah.
I think that apart from those documents that I have mentioned, I will repeat them. These are the basically the application, the description in general form of the description of the liquidated company, and the description of the received assets, as well as documents confirming or showing the value of the assets received. And these documents are quite interesting. These will be either financial statements of the company, or even maybe evaluation report, which will confirm the actual value of some specific assets like corporate rights or like real estate and some others. Apart from those documents, we would strongly recommend to have also the initial decision on the start of the liquidation procedure, also the decision of the liquidator on the distribution of assets, and of course the document which confirms the end of the liquidation. This is a certificate of dissolution.
Yeah, I mean, maybe just to add that those documents shall be properly notarized and apostilled to be used in Ukraine. That also can be a challenge if you forgot about that at the proper moment. What else? We had a question from Boris, but maybe it can be quite interesting for everyone. Is the tax-free liquidation for Ukrainian individual shareholder a form of amnesty from past or undeclared income or capital? And if so, how does the amnesty work? Maybe just to mention that it is not the amnesty. Yeah, it's only the tax benefits for not to pay the taxes in case of receiving income from those liquidated companies, but nothing mentioned about the source of that income. And also, I mean, it's obvious that fraudulent or illegal actions that were somehow connected to that income will not be covered by this tax exemptions. So probably we cannot treat that as an amnesty, rather as a tax benefits. Yep, Taras, could you add something?
Yes, I will just add one thing, that in its initial meaning, the tax amnesty prescribes the fact of some violations, and the tax-free liquidation does not. So it's quite similar things, but not the same exactly.
Agree. We had another interesting questions in one of the applications from the participants about actually what to do with the companies with no prepared financial statements for the previous periods, with no audits, with nothing. I mean, with no documents. What you will suggest in this respect? Either to draft or to prepare all the financial statements for the previous periods, or maybe we have other creative solutions to that. George, Kerry, do you have any ideas?
Kerry, please, ladies first. Happy to step in.
Thanks, George.
Immediately after.
So like I mentioned, in the BVI, there is no requirement for formal financial statements, and neither is there a requirement for audited financial statements unless the company is regulated. So as a liquidator, if the company has completely nothing and has had activities, I would insist on the company preparing some form of financial statements, so I have some sort of visibility. So you can imagine, as liquidator, you're coming into a company where you have not had the benefit of the history of the company. You don't know what the company has been doing, and you're taking the director's word in good faith. So the numbers need to support that. If the company had entirely no operations, for some reason it was incorporated, and then whatever activities it planned to have didn't materialize, then in instances like that, I would waive it as liquidator. However, the legal requirements are that the directors draw up a statement of assets and liabilities. They cannot get away from that. It's a legal requirement, so they have to produce financial statements as at the latest practicable date.
Good.
I think from a civil law perspective, for a member's voluntary liquidation, again, the liquidator would not accept to proceed without having audited financial statements in place. And obviously, the tax clearance certificates that we talked about, which are very important for the liquidator to proceed and affect the distributions of the assets, would never be issued without those. If, as Kerry said, this is not an operating company which just omitted to fulfill its statutory obligations and prepare annual returns or audited financial statements through the years. It's just a dormant company which was created and then was never used. In that case, if that can be shown to the comfort of the liquidator, we would also probably waive the need to have audited financial statements and put the clients into that kind of cost. But otherwise, definitely the financial statements would need to be prepared throughout the years. It's an important cost, but it is the safest way for any liquidator to wind up a company. There is a way around it in that one could instigate a creditor's voluntary winding up, where you don't really need to have audited financial statements, but that would skyrocket the cost for the client, and it probably would cost much less to prepare audited financial statements and go with a solvent liquidation if that's the case.
So in simple words, at first you need to clean up your history, to have all supporting documents. We have one very creative solution here in Ukraine called one-day liquidation. In other terms, in other words, is like the company, the legal company or similar, will buy the company, will change the shareholder and change the director of the company. Is it somehow possible in BVI and Cyprus? Kerry?
I'll let George answer that. He's the partner. I guess it would depend on the risk appetite. It is certainly not something that we have seen in the BVI. And I'm not sure that the partnership would have that sort of appetite for the risk involved, not having had the history of the company. It remains to be seen. It's a very innovative solution, I must say, not one that we've heard of previously. And it can certainly be considered. I think the risks definitely outweigh the benefits for law firms locally in the BVI, though. I'll let George add anything he wants to that.
Thanks. I think Kerry has already covered most of what I also wanted to say. I think it's a risk which most liquidators wouldn't want to assume. It might be something we would be willing to look into, especially if the company had Harneys as a registered agent or as their administrative service provider in Cyprus, but we haven't seen this before in Cyprus. Theoretically, it can be done, but again, the risk would be the weighing factor here for us to consider. So, in summary, we wouldn't dismiss it completely, but it's unlikely that we would go down that route without wanting to say no in any firm way, without seeing all the circumstances and judge on a case-by-case basis.
And I think, just to add, Max, I think it would probably be more cost effective to liquidate at the end of the day.
Agreed.
Yeah. Good, thank you. Maybe just to mention that we had several questions from our current clients that already started this tax-free liquidation, and we had an issue and like a series of questions related to what is more advisable, to transfer the assets, for instance, real estate or the shares of a foreign companies, or to transfer the funds, cash, to Ukrainian resident? Because in some cases you can sell the real estate or other property, and the company can receive the cash and then transfer that to Ukraine. So in this respect, you need to take into account that it's obvious that transferring the cash, the funds, is more easy and with no risks, and moreover, you will not. I mean, you will be more comfortable to receive that in Ukraine. In terms of receiving the real estate or other assets, you need to think what you will do later on with these assets. If you are thinking about selling that, you need to think how you will then optimize your tax base, because this will be treated as your income when you receive this real estate, and then after the selling, there will be no expenses. So you will pay the taxes on the full amount or the full price of your real estate. So there are no options how to optimize that by deducting the expenses. So it's also very important, and maybe to consider that when you're thinking how exactly structure your tax-free liquidation. Taras, do you have any practical tips maybe for our listeners?
Yes. Do you hear me well now?
No.
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 And now? How it
Yep. Yep.
Okay. So basically, the main tip will be not to postpone this long-lasting process and not to postpone the decision on what to do with a foreign company. You have either to decide to wind it up or to continue using it, but maybe in some other way. Also, from my personal point of view, the process is really complicated and has different pitfalls. So I believe definitely a lawyer will be required in this process. So maybe this is it from the main ones. Yeah.
Good. Do you think practically it is possible to finalize the liquidation by the end of this year? Taras.
As one person said, nothing is impossible. So I think yes.
Oh, that's Ukrainian approach. Yeah, definitely. Kerry, George, maybe any practical tips from your side?
Yeah, on the point that you mentioned, Max, about whether to accept distributions to real estate or cash, there are tax considerations to take into account in Cyprus, and also there might be Council of Ministers permissions that need to be secured before any real estate is transferred to a non-EU citizens. So certainly it's important to also get, if we're talking about significant assets which may produce significant tax obligations, it would be prudent to secure tax advice before going into liquidation, so that you know exactly what is your roadmap and what your liquidator will be asked to do, so that you don't have any delays.
Yeah, just on that point as well, the liquidator would also have to consider the liabilities or creditors of the company. If there are insufficient liquid assets to pay those off, then the liquidator would need to consider selling or liquidating the other assets in order to meet the obligations of settling the debt of the company. As a practical tip, I would say that all the service providers should be lined up, like Taras mentioned. Depending on the type of assets, if the company needs to, or if the UBO needs to receive a property, for example, there are practical steps in the jurisdiction in which that asset is located to transfer that. I would just urge companies to get all of those lined up before they place the company into liquidation, so that everything happens smoothly and there are no delays when it comes to the distribution of the assets.
Maybe just to add final word about the terms and deadlines of liquidation, there are certain opportunities to extend the period of tax-free liquidation, and you can use them also. So as said by Taras, nothing is impossible. Thank you very much, George and Kerry and Taras. That was, I think, very practical, very interesting, and it's really hot, interesting topic. Probably we will have another opportunity to talk about other interesting topics related to your jurisdictions.
It was
Thank
our
you, Max.
pleasure, and thank
Thanks
you very
for
much for
having
the
us.
debate. Yeah.
Thank you for participants and for your questions. Stay tuned.
Thanks,
Bye-bye.
everybody.
Thank you.
Bye.
Bye-bye.